You want? I'll start now. I'm going to start now. Good morning, everybody. I want to welcome. Okay, we're admitting someone else. Good morning, everybody. Welcome back to the new season for the Family Provider and Care Management Information Committee. My name is Deborah Greif. I am the parent co-chair, and I'm with my co-chair, Ms. Sauls, which I will introduce and will be introducing, and she will take over because she signed up a very excellent speaker with the subject that both parents, professionals need to be kept up to date on, which is different forms of guardianship as well as special needs trust fund. And we also would like to ask you that if you have ideas or have any questions or concerns, please let Rose and myself know by email. Now, without further ado, let me introduce Ms. Rose Sauls, my co-chair. Take it away, Rose.
Thank you, Debbie. Good
You're
morning,
welcome.
everyone. Welcome, welcome, welcome. My name is Sauls, and I'm the Division Director at Brooklyn Community Services, and I am the co-chair here for the Family and Provider Care Management Information Committee, which is a subcommittee under the Brooklyn DD Council. We are so happy to have all of you on the call. I hope that everyone had a wonderful and amazing summer and are ready to start this new fiscal year. As Debbie, my co-chair, had mentioned, we really try to provide resources, to families and providers as well as, and care management as well. We want to have the right training. We want to give you all the information, all the tools that you need. So we invite you to come up with ideas to let Debbie and I know what topics you would like for us to be talking about. We don't want you to come here every second Wednesday of the month and not get the information that you need, right? So please let us know. You could put it in the chat, let us know what you are interested in. If you also know of family members that can benefit from this committee, please invite them. Invite them to come on, get the information. I know we have a lot of time providers on the call. If families are on the call and you felt like your questions are not being answered, or you don't want to ask the questions on the call, you could always put it in the chat. You could always reach out later on to Debbie and I. We are trying something new for this time. We want to invite any speakers that we have on the calls back. If you guys have any questions that you would like an answer to, you didn't have a question at the time that we were meeting, but now you thought of a question, you could also put that in the chat, and then we could have a Q&A. We could welcome you back. You can have the contact information of the speakers. Please, again, we want to make this meeting as productive as we possibly can, and we want to give you all the right information. And if we don't know, we will find out and get back to you. So please, again, invite someone in the committee. We want this committee to have a lot of impact. So invite someone that you think that will benefit from the committee. Invite your family. If you are a CCO on the call and families always asking questions, invite them to this this meeting. We meet every second Wednesday of the month. I know sometimes the time might be a challenge for family, and if we're getting a lot of family that's saying that the time is not good for me, the time is not good for me, maybe we might think of something new. Maybe we'll switch our time to see if that works for family, right? And the meetings are also recorded, right? So families can also have the link to go and get that information, and reach back out to us if they have any questions. All right, I think that was a mouthful. I don't remember if I breathed as I was going through all that. But I am excited to run this committee again alongside Deborah and also Christopher Greif, who's our great moderator for the committee. I just want to start right away with I guess before I start, I will let Chris go to the housekeeping rules, and then I will introduce our speakers.
And good morning, everyone. This is Christopher D. Greif, and as Rose and Debbie say, welcome. Just to remind everyone, some of our devices have been updated, so we want to remind everyone that we do have caption is available, not just in English, but in different languages. So If you know that you do speak in a different language, you can please go into more, depends what device you're on, and look for the able closed caption. It is programmed, unless you didn't update it yet. I don't know that. But hand raises are available, as Rose mentioned. If you feel you don't want to raise your hand or you want to put your comments in, your comments will be in the chat and we will be reading your questions in the chat so we can give you an answer. As a reminder, as Rose and Debbie have said, if you have any ideas, please email it to the care. Please make sure you email them both to let them know for any idea speakers. We also remind you to please pass the word to families as well, because this is something they can get a chance to watch on the YouTube channel. And yes, this video will be located at both councils' websites, DD and advisory as well, as we try to keep the videos moving forward. Just to be advised to everyone, at 11 o'clock, we do have the Legislative Committee. We ask everyone to please attend that meeting to hear your ideas and thoughts for the future of not just 2026, but any ideas and things the councils need to do to the future of that. And that's from 11 to 12. So just want to remind you, you don't need to get off the Ring Central. Stay on. It's the same code. You don't need to. And if you want to find out when meetings are, not just the DD subcommittees like Rose and Debbie, you see the QR code right here. Scan it on your phone, and you can go right to the calendar, seeing where meetings were, not just the DD, not just provider, but all meetings, including the advisory and DD council meetings. And every meeting is virtually at this time. They do record them, so please share your information to the families as well. So at this time, I'm going to give it right back to Rose Dow to get ready to let's start the party.
All right, thank you, Chris. As Debbie mentioned earlier, we have an amazing speaker, and we understand, again, planning family guardianship and trust is a very important topic, to family members and also for providers and our care managers, to understand. So we have invited Malkie Scher to provide some resources and some information to you. She's from the Masco's Legal Group Foundation, attorney at law. She will be presenting, and we do have a PowerPoint presentation. So if anyone have any questions later on that they would like for us to address, please let us know. And then, like I said earlier, we may be inviting speaker back again, so where we could do a Q&A and we get everyone questions and concerns addressed and answered. Thank you. Malkie, if you can tune in, we are going to pull in your presentation and then you can get started. Welcome. If you want to add a little bit more about your experience, your background, and how long you've been doing this, that's also welcome.
Sure. Thank you, Rose. Thank you so much. It's a pleasure to be here. So my name is Malkie Scher. I'm a lawyer at the Moskowitz Legal Group. I've been here for a few years now. My specialties are special needs planning and guardianship. Before this, I was a special education attorney. I worked in that field for about 4 years, and I pivoted to this afterwards. So today I'm going to be speaking about two different topics, but they both should be pretty relevant to everyone here. They're not really connected, but they're connected in the sense that it's just things that everybody should be informed about, and they're important topics, but they really are separate. I often give separate seminars on just guardianship and just special needs planning. But about a year or so ago, I was speaking at a school, and they asked me if I can shorten both topics and speak about both of them. So now I started doing this type of seminar too. So if you have, I usually like to do 15 minutes of me just talking and then leave as much time for questions at the end. That's usually the way that I like to do it, but I will be speaking a little bit briefer about both topics. If you'd like to know about other seminars I'm giving, if you want to hear about one of the topics more in depth, you could contact me afterwards. Okay, next slide, please. Okay, so we're going to start with special needs planning. So these are the topics I'm going to go through. So what is estate planning and why is it so important. Just the basics, wills and trusts. I know most people here have heard of both of those terms. I think it's important to actually go through what those definitions are. Advanced directives. These are actually talking about advanced directives for yourself. A lot of the estate planning is, and when I say yourself, I'm sorry, I know I'm speaking to a group of people. So when I say estate planning, I'm really talking about the parent's own estate planning. The parent's own estate planning that they're doing, where they're keeping in mind their child, who may be an adult child, but their child who has a disability. So really, you need to do estate planning for yourself. And I'm sorry, I'm going to keep saying you, and I know many of you are not necessarily parents. It's just easier just for, how it comes out. But I'm talking about the estate planning for the parents. And then what you can do now. So if you tune out during the entire seminar too much, it's hard for you to focus on it. That's fine. Just make sure to tune in the last few minutes, and I'll sum it up in what you could do now. Okay, next slide. So I want to start talking about a real life scenario. Oh, here. So what is estate planning? Estate planning is when an individual decides what will happen in advance to their money, property, and belongings after their passing. It's a simple idea, but that's what it is. That's what, when someone says estate planning, that's what they're talking about. If you don't have a plan, nobody's going to know what your plan is, because unfortunately, you won't be here anymore. So we're going to talk a little bit about estate planning and why it's so, so crucial for families who have an individual with disabilities in their immediate circle to be making an estate plan. Okay, now we're going to talk about our real life scenario. Next slide, please. Okay, I'm going to take this scenario. Let's say you have a married couple. You do not need to be married in order for this to be applicable to you. I'm just doing it for the scenario. They're in their 40s. Let's say they have 4 children, 3 of which are under the age of 18, and 1 is an adult child who has some sort of special needs. The most crucial part being that they're receiving government benefits, Medicaid, Social Security, SNAP benefits or whatnot, Medicaid and Social Security really being the most crucial. So what will happen if one or both of these parents pass away without having done proper estate planning? Next slide, please. So to start off with talking about this, the first and most crucial part of an estate plan is doing a will. The formal term for that is a last will and testament. A will is basically an instruction guide for how a person wants their assets and property to be distributed after their passing. It also can name guardians for your minor children. This has absolutely nothing to do with guardianship, which is what we're going to talk about in like 5 minutes from now. This is just talking about guardians for minor children, right? If somebody passes away, they leave behind a 7-year-old child, they can actually write in their will, I want such and such, I want their aunt to be their guardian. And it makes it a pretty smooth process. So this could really just be applicable for anyone who even has a minor child, how important it is to have a will, because you can name a guardian in there. But your will is your instructions. You don't have instructions, no one knows what your instructions are. So why do you need it, right? Like, what happens if you don't have the will and you don't set those instructions? So why do you need a will? Next slide, please. The 3 main reasons of why somebody would need a will. So 1, naming guardians for your minor children. It is so easy. You write it, it's 1 line in a will to say who the guardian is. Unfortunately, our firm handles a lot of work after people pass away, right? We do administration and probate. And it's really, really messy when people don't name a guardian for their child. The family's already going through a lot. Somebody passed away, probably at a young age if they're leaving behind a child who still needs a guardian. And it's very complicated. Who's going to take over guardianship for that child? Who's going to be their custodian? Who's going to be their new parental figure? But if the parent just writes it down in their will, that makes the process much, much, much smoother. Next, appointing an executor. This is your manager of everything part of your estate, right? Your house, any bank accounts you may have, sorting out any money, handling funeral arrangements, appointing an executor that you trust to know to take care of that process could be very reassuring. And the last, but most importantly, is asset distribution. Your will specifies how everything's divided and who it's divided to. So what happens without a will? Next slide. The three biggest issues that happen without a will is a problem for a surviving spouse, if there is a surviving spouse, problem with the child with special needs, and problem for minor children. So one, problem for, well, just to understand, there's some, in New York, there is an automatic way that your assets get distributed if you don't say otherwise. New York law has a way that already all your assets would go without regard for your specific desires, your specific family dynamic. It's just the way the law says it, and that's what has to be followed unless you make a will. So typically it goes in New York State that half the money goes to a surviving spouse, and then the rest of the money gets split between all children. In theory, it could sound nice, right? Okay, all the money staying within your family if you're married, assuming you want money to go to your surviving spouse. If you have kids, it's a good assumption to know that you probably want your kids to get some of the assets. But in reality, this can be a living nightmare. It could lead to major complications. So the biggest problem for a surviving spouse is that, taking that example before with the 40-year-olds, I mean, they're 40 years old. They have so much of their life still ahead of them, and they probably have a ton of expenses. Let's say they have a house. They're probably still paying off a mortgage. Let's say there's kids, go to a certain kind of school or program that needs to continuously be paid for. What probably that family would want is probably a lot of money, or maybe all of their money, to go to their surviving spouse to be able to pay for their life to continue as usual. So it could be extremely frustrating to that surviving spouse to only get a portion of the money, and then dealing with what happens when minor children land into money, a child with disabilities landing into money when the surviving spouse is just dealing with so much. He or she is 40 years old. They have all of these expenses. They're trying to keep their life as normal as possible after, unfortunately, one parent has passed away. And now they have to deal with how New York law is saying that their money should go. Even if they're saying, I don't want it to go that way. I need all of this money, or my mortgage is, $3,000, $4,000, $5,000 a month. That's like a huge chunk of their money, that their grocery bills, whatever it is that they spend money on every month that they need to stay the same, they probably really need that money. And it could be a living nightmare for the surviving spouse if you don't have a will. Next, the first time we're actually mentioning someone with a disability, but really estate planning is really important for everybody. So I really needed everyone to understand that. But obviously we're here to talk about somebody who has a disability and why it's even more crucial for a family that has a child that has some extra needs. So if a child or adult, if an individual with special needs inherits money directly, they could immediately lose eligibility for vital government benefits like Medicaid and Social Security. I think that often goes overlooked with estate planning because parents and people are so focused that during their lifetime to be making sure everybody knows, don't keep too much money in my child's name. They need to get their government benefits. Medicaid could be crucial, paying for medical bills. Social Security could be important too. People are so careful during their lifetime. They know, oh, my child has a disability. I am going to make sure not to put money directly in their name. But what people don't realize is after their passing, your child, your adult child, your minor child, whatever it is, they're going to have money go directly in their name. That's the way it works in New York State. You have a child, they're getting money. Unless you make a will to kind of set those details out and make sure that it doesn't go that way, automatically your child with a disability is going to lose their benefits. And like I said, I don't work directly in that department anymore, although I help out in it a lot. we handle what happens after people pass away. You know, whether people had an amazing plan and everything goes accordingly and it's super simple to make sure their assets get divided, or people who have very, very complicated scenarios. They have minor children, someone with a disability. They didn't realize, they thought they didn't have so much money, but really they own this apartment. And now all of a sudden, their child with a disability lands into money. It doesn't even need to be that somebody's so wealthy to be considering this. $2,000 in their name could just jeopardize their government benefits right away. And that's very scary and unfortunate that I think a lot of people don't realize how important the future planning part of it is, and not just to think about it during their lifetime, but what happens after they pass. And lastly, just to talk about minor children, because this is something that it's pretty important people to realize, is first guardianship for your minor children, right? To have to deal with after a parent if both parents pass away, you know, who's going to take care of this minor child? Who's going to do all the things that they need for them, sign their school papers? That's always the first thing that happens. They always say like, oh, I try to enroll my child, and I try to enroll, like the great aunt starts taking care of a child after her sibling passes away, and now the child is living with her. She's not formally the guardian yet. She can't get the school papers signed. And she said, school's not even letting me enroll. And it's so complicated. If they just would have written in the will, like this great aunt is who we want to be the guardian, the process would have been much smoother for them to get appointed. Again, this type of guardian is just for minor children. For somebody who has special needs as an adult guardianship, that's what we're going to talk about in a few minutes. I'm just talking about for someone under the age of 18, regardless of whether there's a special need or not. And also with minors, in the state of New York, someone under the age of 18 is actually not allowed to inherit money. So that's very complicated, because now this parent just passed away and they're due to get 1/4 of the money or whatever it is, but they're not allowed to get it. So the process of what you need to do for a minor child who inherited money because their parent didn't have a will is very, very complicated. You need to go back to court. It's very expensive, and it's a whole process of where these funds need to go. They get locked in what's called a guardianship account for minors, and they may not be able to touch it for a while, or it may be very specific how they could use that money. And again, going back to the problem for the surviving spouse who's just trying to keep everyone's life as normal as possible, he or she wants the money to be as free as possible so they could keep living their life, instead of keeping the money locked up into different metrics that the court is trying to put it in, because legally minors can't inherit money. Okay, so all of that is just me saying, make a will, have a will, the most basic will ever, just putting some directions in so the state doesn't decide for you. Something I like to just mention is if somebody has a blended family, or if somebody has any children in their family that has an estranged relationship, things can get even more complicated, because what the law says is that all your children will inherit. So if someone has a child who they haven't spoken to in 20 years, maybe for good reason, the state doesn't care or know or understand the complicated nature of what's going on with that relationship. Because they're a child, they're going to inherit. So it could be very complicated. Also, let's say somebody has children from multiple relationships. It could be very complicated when you have a blended family, or where you have children from different relationships, because the state doesn't know what your wishes are. Let's say you have a stronger relationship with this child, and maybe for this child they don't need so much of your money, or maybe, you know, this relationship, whatever it is, don't leave it up for the law to decide. Write it down on your will. Only you know, and again, you just is talking to the families, only you know what makes sense for your family. So write it down, because otherwise no one's gonna know. Okay, next slide. So now we're gonna talk about trusts. There's multiple different types of trusts in New York State. I'm really just gonna focus on the special needs trusts. So just a definition of a trust. A trust is a legal tool where one person manages money for another person. It's just a legal arrangement where one person is managing the money for another person. So somebody is the manager, that person's called the trustee, and somebody is a beneficiary. That's the person the money is being used for. And a trust is basically this loophole where that beneficiary, the person that the money is being used for, the money's actually not considered theirs, which is a very nice loophole for Medicaid and Social Security, and why trusts are so popular, because the money will be used for the beneficiary, but it's not considered theirs. It's a loophole. I'll explain a little bit more what that means, because that concept could get really tricky very easily. But let's talk about a special needs trust. This protects individuals with disabilities from losing government benefits, like Social Security and Medicaid, if they acquire too much money in their name. Even a small amount of money could disqualify them from their vital services. So it's a loophole. And as an estate planning tool, this is how it would look. Okay, I'm taking the couple who's 40 years old. They're coming into my office. So they say, hi, we have 4 children, 3 are minors. We have a child with a disability. We want to set up our wills and we want to do future planning. So we set up their wills. They want all 4 of their children to inherit equally. So for their child who has a disability, they don't want to just leave them out of their inheritance. They love their child and they care about their child just as much as they care about all their other children. So what could they do to make sure that that child still gets all of the money that they want them to get, but it's out of their name? Because if it's in their name, Medicaid and Social Security is not going to like that. So what we do for them is in their will, we say, let's say Joe Schmo. Joe Schmo's portion will go into a special needs trust. That's the way that it looks as a future planning tool. So they could say that for their other children, the money goes outright to them. And for Joe Schmo, the money would go into a special needs trust. And maybe they'll have one of the other children manage it for them once they become an adult, or they'll have a person that they trust very much to be the trustee. But all of the money in the trust must be used for Joe Schmo. It has to be used for him. That's what the law says, but it won't be considered his. It's a loophole. It's a legal loophole. It's not sketchy, it's not back ends, it's nothing like that. It is a loophole that is allowed to be used, but it's a really, really important loophole to know about. Because although government benefits are extremely helpful, it's probably not enough for somebody to live on. So Medicaid and Social Security, important, vital, keep those protected. But why shouldn't this person with a disability be able to have more money being used for them? And that's what that special needs trust does. It locks that money in to only be used for that individual, but somebody else is managing it and it stays in a trust. I'm sure everyone will have a lot of questions about that afterwards, which is totally fine, but I wanna move on a little bit. But the funds in the trust are usually used to enhance someone's life, covering things that Medicaid and Social Security would not typically be covering. So it could cover things like vacations, entertainment, fancy clothing, certain medical expenses maybe that Medicaid is not covering. The biggest rule is really just that it has to be used for that individual, but the rules could be kind of lax how it's used for them. So the 2 common ways that special needs trust comes up is 1, like we said already, leaving money through your will. That's called a third-party trust, where the parents leave money in their will and say that Joe Schmo's portion goes to a special needs trust, a future planning way. But another way that some of you may be familiar is what happens when there's already money in their name. So the most common way is like through a lawsuit settlement. Let's say somebody has a lawsuit settlement, they sue the hospital, something happened, and all of a sudden this individual with disability lands into $500,000 in their name. That's definitely more than $2,000. So what are we going to do now? There's also a special needs trust that you could set up to take that money out of their name and put it into a special needs trust. The rules work a little bit different from the other type of special needs trust we just said, but similar concept. The money goes into the trust instead of in their name, with a manager, a trustee, managing it on this individual's behalf. Okay, next slide. And this is really just the last one on special needs planning. because I really want to move on to guardianship before everyone's minds get too fried from this topic. But this was the point where I said, if you're spacing out before, it was too wordy, you weren't really hearing everything that I was saying, focus now just for a minute, because hopefully this will sum up some important things for you. But simple estate planning could prevent major problems. What could you do now? If you do nothing, just make a will. Make a will. Make instructions for how your assets should go. Consider a trust. There's other types of trust to consider too that often people like to do. I don't want to go into them right now. But specifically also a special needs trust. Most people who have an individual with disabilities in their life should be setting up a special needs trust. Whether this individual is extremely high functioning and whether maybe they're a little bit lower functioning, it really doesn't matter. A special needs trust could be very, very beneficial to help them live their fullest life and keep their government benefits. I'm just going to mention advanced directives. This is talking about for the parents. So every individual, whether you're older, younger, you have a disability, you don't have a disability, every individual should have advanced directives, as long as you have the capacity to sign them. Really, even just a healthcare proxy and a power of attorney. This is something that as a parent, you are doing as a gift for your children, to not make yourself a burden once you get older. So back to my example with the 40-year-olds that are coming into my office. The best thing that they could do for their kids is to each have a set of advanced directives on themselves that says, if they were to lose capacity, so meaning these parents, they're 40, they're young, they have a lot of years above them. What happens when they turn 95 years old? Maybe they develop dementia. Maybe they lose capacity. What's going to happen then? We deal with that at our office too, with people that become much, much older, who lose capacity, who don't have advanced directives already in place. Very, very complicated type of guardianship proceedings get done. Very, very expensive type of guardianship, specifically for people who are older, very different than the type that I handle. But the best thing that parents could do for their kids, besides for making a will, is just sign advanced directives. It takes 2 minutes. It just is a healthcare proxy and power of attorney. And it just says, if I were to lose capacity and not understand how to make my own decisions, these are my designated people who can make my decisions for me. And at 40 years old, those documents go into a drawer and you don't use them for a very long time. But when it's time for you to use them, at least you have all your paperwork in order and you have designated everything appropriately. That's how you make a full estate planning. Okay, time for guardianship. Next slide. Now, guardianship is really not connected to special needs planning. They're just both really important topics that I feel really passionately speaking about, which is why I'm combining them, but they're really not connected. So take everything I just said and just put it to the side for a minute and try to focus on this new topic right now, because it's equally as important and it's just different than what we were just speaking about. What is guardianship? So I'm going to speak about what is 17A guardianship. That's what it's called, 17A guardianship. That's the type that I handle for a person with an intellectual or developmental disability. I'm going to talk about some guardianship scenarios, where it's really coming up, where it is that people are calling my office and say, I need guardianship because such and such just happened to me and I require guardianship to move to the next step. The next bullet point is what I spend probably most of my time doing, talking about, is guardianship right for your child? Again, I know I'm not necessarily talking to everyone who are parents, but I'm just going to keep saying yours because it's a little bit easier for me to speak like that. So is guardianship right for your child? Guardianship is not right for everybody. That's important to know. But it's something everyone should be considering, but it really just may be an inappropriate choice for your family. And we're going to talk about why, and just that whole concept of what kind of analysis you should be doing to decide if it's right for this individual or not. And then we'll talk about some alternatives. If guardianship is not the right route, don't just ignore it and say, okay, guardianship is not right for this individual, therefore we don't need to do anything. You should heavily be considering alternatives. Next slide. What is guardianship? So when an individual turns 18 years old, The law now presumes that that individual is able and capable of making all of their own healthcare, financial, and personal decisions. This is an automatic assumption by the state. However, someone, and I'm going to call them a child, I'm going to keep saying child, but I'm talking about somebody 18 years or older now. So a child with an intellectual or developmental disability may or may not be able to continue, may or may not be able to make their own decisions. So without guardianship in place, you may encounter challenges, making it much more difficult for you to continue assisting your child the same way that you've been doing so for the last 17 years. And I want to talk about those scenarios that come up where people start hearing about guardianship for the first time. I'm a big advocate for people thinking about it before they land themselves in a situation. It's something people should plan ahead for. At 17 years old, you should start thinking about guardianship. But I also want to just explain some scenarios where people might be directly told, you need guardianship. And now the parent has to start scrambling and thinking, okay, well, how do I get guardianship? Okay, next slide. So the biggest time it's coming up is with healthcare decision making. It does come up with financial affairs. It's a little bit more complicated with financial affairs. If anyone has questions about that, I could speak about it afterwards. But actually, the most common type of 17A guardianship does not involve finances at all. The court is not a fan of doing guardianship over somebody's finances, and they make it very, very complicated. So really, if somebody does have money in their name, I usually try to advise them on ways to get that money out, and therefore we don't have to do guardianship over their financial affairs because the court makes it a miserable process. But the healthcare decision-making part is not a miserable process. It's a little bit more straightforward and it's important. And also just residential and housing decisions. If you're somebody's guardian, you're allowed to choose, where they live, and some schooling things as well. Healthcare decision-making is by far the most common and important scenario, though, where it comes up. Technically, once your child turns 18, the doctor is no longer authorized to speak to you. Technically, you need to leave the room, and the doctor is not allowed to directly speak with you or ask you questions or allow you to make decisions. Now, that could be really scary. It could be very scary, obviously, if your child may be lower functioning, but it can even be scary if your child is very high functioning, because maybe they're dependent on you kind of being someone that helps guide them. Because even if somebody is very high functioning, if they do have a disability, chances are they still need some assistance in some way. So some people may not notice this at the doctor right away, because oftentimes a primary care physician who knows you, and maybe if your child is still going to the pediatrician, they may give you some leeway. It may not be that the day your child turns 18, they kick you out of the room. So oftentimes parents first realize this when they go to a new doctor or when they go to a specialist, an ENT, a pulmonologist, whatnot. Almost every time parents call me crying from the hospital, because you will always notice it at the hospital. Because a hospital is a place where doctors really don't want to get sued, and they want to do everything completely by the books, and they don't want to touch a patient without knowing that whatever proper documents need to be in place are in place. So I have had someone call me from the hospital on the day of their son's open heart surgery. They had scheduled this surgery when their son was 17. Nobody told them about guardianship. After all, their son was 17 and the parents were authorized to make all decisions for them. Surgery got pushed off a little bit, and the individual ended up turning 18. And the doctor was literally scrubbed in, like in TV when they scrub in, they're about to go into the room, checks the file, sees that the child has turned 18 and says, "I'm sorry, I'm not touching him." Parents are screaming, they're freaking out. They're like, "Our child needs open heart surgery. This is obviously crucial. Can you just do it?" And the doctor says, "I'm not getting involved. You have to get guardianship." And the parents called me, and I try to help them with some other mechanisms. In the meantime, you can't get guardianship overnight. That's just not the way it works. Sometimes you could do it quicker, but there's no way for us to have gotten guardianship in the time that he needed it to finish the procedure that day. So it's really scary and it's really frustrating. So you don't want to wait till the day of a major procedure to realize that guardianship may or may not have been necessary. And like we said before, it also comes up with financial things and residential housing decisions. I don't really want to spend so much time on that today. If you have questions about it, ask me afterwards. Okay. Most important topic is the next slide. Is guardianship right for your child? Again, I'm calling them a child. We're talking about someone 18 years or older. What are you looking at to know if guardianship is needed or important or necessary? The word is going to be capacity. That's the word that's going to be brought up, and that's what people are going to be analyzing, capacity. Does this individual have the ability to understand and make decisions? And sometimes that line is really, really hard to draw. So first, they have to have an intellectual or developmental disability. I had someone call me a few weeks ago. I'm laughing just because it really was funny, but I feel bad. She really was in a tough spot. But she said to me that her son is 18 years old. He does not have a disability. But recently, he got into this crowd and his friends were trying to convince him to smoke weed. And therefore, she wanted guardianship. I told her that's just not a valid reason to get guardianship. We had this back and forth and back and forth. I ended up just saying, maybe you could sit down with him. Maybe you could, try to be a good influence on and whatnot. It was funny, but really she was very stressed out about it. She didn't want her son to be in this bad crowd. They were doing all sorts of things. But I think sometimes people just miss that first point. You have to have an intellectual or developmental disability. If your child is making bad decisions, maybe there's things you want to explore to help encourage them to make better decisions. But guardianship is taking away somebody's ability to make their own decisions. So if your child does not need you to do that, you should not be thinking about guardianship. Just to understand that. So first, they need to have an intellectual or developmental disability. Second, you need to assess capacity, because this is what the court's going to be looking at. And different courts have different standards. Everyone here is probably talking mostly with families in Kings County, right? Thumbs up, thumbs down. All I could see is rose on my screen. Everyone else is black. A thumbs up. Okay. So Brooklyn is a pretty fair county with how they do their guardianship. I kind of agree usually with the way that they make their assessments. Some other counties are far too strict, where they don't grant guardianship in cases that I think are blatantly obvious. And honestly, some counties are far too lenient, really just giving out guardianship to anyone. So I would say that Kings is actually a pretty good assessor in whether this individual actually requires a guardian to make their decisions. This is what the court looks at, and this is what you should look at before pursuing this for your child. So these are some questions. Can the individual travel independently? Can they administer their own medication? Can they attend doctor's appointments on their own? Do they have a concept of time? Do you feel that this individual will be able to obtain a driver's license? Can they hold down a job? There's many more questions to ask. Those are just some of the questions I feel like the court asks a lot about. So the more of these things that the child cannot do, the more likely guardianship will be needed. But if you call me up and you're saying that the individual could do all of those things, you have no chance in receiving guardianship because the court's not going to order it. So what I like to say is I make 3 boxes. I hate making boxes because people don't belong in boxes. And I'm obviously a very connected person to the special needs world, and I would never want to put someone in that kind of box of low functioning and high functioning. What does that even mean? And, whose opinion should that be? But in terms of a legal proceeding, you need to put things in boxes, at least in your own mind, in order to be making the right decision. So there's 3 boxes: someone who is lower functioning, someone who is extremely high functioning, and then all the people in between. So if somebody is extremely high functioning, they have a job, they may be able to live independently soon, they're studying for their driver's license, they go to appointments on their own, they could basically take their medications themselves, maybe you have to give them some reminders, they do the shopping for the house, you know, maybe they have Down syndrome, but they do all of those things. You're not going to get guardianship. Don't do it. Don't try. It's not going to be fun. The court is going to kick you out of the courtroom and say this person is far, far, far too high functioning to be getting guardianship. Okay, then we have the other end of the spectrum, somebody who's clearly low functioning. If they're nonverbal, if they are not able to show you that they can make their own decisions, if they are 100% completely dependent on you, of course you need guardianship. You're really not going to have a different alternative that works well for you. But for all those people in between, where the individual may be considered higher functioning in some ways and lower functioning in other ways. Rose, you have a question?
No, I just want to let you know we just have 10 more minutes left. I'm not sure how many more slides we have.
Yes.
Like one more
Malkie?
slide.
Okay, all righty. Thank you.
If anybody
Okay.
has questions, please place them in the chat, and we'll figure a way to get them to Malkie. Because 11 o'clock is the legislative committee, unless they don't mind
Okay,
giving
I'm
us
gonna,
another.
sorry about that. I'm gonna go as quickly as I can.
All right, go ahead.
Okay,
Thank
so
you.
let's go to alternatives. I'll stop beating that point to a bush. Alternatives to guardianship. If guardianship is not appropriate, don't do nothing. Just because someone is very, very high functioning doesn't mean that they may not need some assistance in some ways. I'm a big, next slide. I'm a big proponent of doing advanced directives, like a healthcare proxy, power of attorney, HIPAA release. These are important legal documents that if you have them in place could be very, very helpful. The biggest part of the advanced directives is somebody has to have capacity to sign them. So if someone is truly high functioning and they would understand what the documents mean, they could sign advanced directives. You can't really try to do advanced directives for somebody who's really very low functioning because no one's going to respect that. So if a very low functioning individual is going to a doctor's office with their HIPAA release or healthcare proxy, the doctor's going to look at you like you're crazy. They're just going to say, this is not, these documents are not valid. This person did not understand what they meant when they signed them. So for someone truly high functioning, advanced directives could be very, very helpful. I can't go into all of it right now because we don't have so much time. There's also something called supportive decision making. It's a very nice concept to look into. You could Google it. This is really not something that lawyers would typically be assisting with. Supportive decision making is an informal process where an individual could pick a team of people who they trust, maybe a doctor, maybe a care manager, maybe a psychologist who helps them make decisions. It's a nice and helpful process, although it's not binding. You can't take a supportive decision-making agreement and bring it to the doctor and tell the doctor that he has to follow it. It's really much more of something for the individual themselves. And if it's something you think that they would appreciate, an informal agreement to help them, then you should do supportive decision-making as well. But don't do it without advanced directives. Advanced directives are binding and they could be very, very helpful. Okay, next slide. Getting appointed 17A guardian in the New York Circuit Court system, you could do this without an attorney. I am an attorney. I do handle this process for many people, but I do know some people who have not hired someone and they have done it on their own. But it is a lot of paperwork, and sometimes it could get a little bit sticky, especially if there are some family members that are absent. So if there is one parent that's MIA and you can't find them, sometimes it gets a little bit more hairy. Sometimes it gets a little bit complicated with the doctor's portions too. But for very organized parents who may have a little bit of extra time on their hands, maybe try to do it yourself because it is something you could do without an attorney. But if you don't have time, patience, or energy, you can hire a lawyer to do it. You could call me. I'm happy to just chat with you for a few minutes and even decide if this is the right method for you. I just want to say, you could do the next slide. But when you're choosing a guardian, it's probably going to be the parent if they're involved in their life. It's also a great opportunity for you to choose your backup guardian. So if you if you, let's say both parents want to be guardian or either one parent wants to be guardian, also make sure that you're listing some of the other siblings or aunts or uncles or cousins or a loved one in the family to be that standby guardian, that backup guardian, because it could be really, really helpful to have that designated already. And it's really just one extra form when you're doing the guardianship proceeding. And it could be a lot easier and a lot less of a headache of what would happen when the parents pass away, or maybe when they get a little bit older and maybe they're just not in the position to be the guardian anymore. Maybe the older sibling wants or younger sibling wanted to take over at this point. So just make sure that you are thinking about that. Who's the appropriate person to be the guardian? Who's a good backup? Who would make sense? Okay, I'm going to stop talking because I only have 6 minutes. Do you want me to take 6 minutes of questions? Tell me how you want to do it.
Yes, we thank you so much, Malkie. We do only have 6 minutes. We did ask folks to put questions in the chat if they did have any question. I didn't see any questions or comment in the chat, but we're going to open up the line if anyone.
This is Chris.
Hi, good morning. This is Lucina. Thank you
Go ahead,
so much
Lucina.
for that information. Very, very informative. By chance, can you give us like a ballpark? Because we deal with so many for families that they can't afford, or doing a will can be costly for some or not. Can you give like a ballpark? And if you're allowed to do that, how much that might cost?
Rose, is it something that you want me to speak about?
I don't know if anybody else are interested in that question. I think it's more like personal. Lucina, I think you might want to reach out to
Lucina,
Malkie.
you have my email. You could email me. I'd happy to speak with you about it. Okay, excellent.
Rose, this is Chris. I just want to remind people, if you have a question, can we please use the hand raise, because it's kind of throwing everything off. We just got to make sure that we can please use the hand raise, because we need to keep control, because we're trying to finish this meeting as soon as possible. Rose, there is a question that was in the chat in the private sector. The only question that they asking for, and it's already on the screen, so I just want to be very clear to everyone. Please email her or call her. That's what is there. So just to be clear for the record that information is available. That's the only question at this time, Rose, on the private sector. There's no other questions on the chat, unless someone has a hand raised.
Okay,
Okay,
1 minute.
thank you,
But I do,
Chris.
Yeah. By the
Yeah.
way, this is Deborah. In reference
Hi,
with
Deborah.
fees, hi, Malkie, I don't think it's a good idea for us to discuss it online, because
Great,
everybody,
email me. Just email me. Yeah.
Already said that.
that's
Yeah, we're
what,
they're gonna email her.
but we will also, Malkie, I will see, we both will have you back. I will also have you present at the advisory council. So this won't be the only time, because I know everybody's
Correct.
gonna have tons of questions, but we're limited. So I understand, but that you gave a very great presentation, and a lot of us we do all appreciate this. So we will make sure you're back with us.
Yes,
In-
thank you, Malkie. And I also wanted to share that we will probably do a Q&A, if people have more questions, please jot them down now, so before we forget, before we get off the call, and then maybe we'll have a Q&A session and bring Malkie back just to do Q&A on these topics. Okay. I saw that Doris, we have
idea.
1 more minute. I did see Doris' hand, so I'm.
Hi, good morning. Thank you, Malkie, for an excellent, clear presentation. I just want to know the time frame. Should someone who have a handicapped child do this right away? Is there a time when they should do it or consider it? And also, let's say they set up everything, a will, guardianship. Can it be changed? Because in life, things do change.
Great question.
People remarry, people, whatever, things happen. Things have somebody you establish as a guardian is no longer able to be the guardian for whatever reason and stuff like that. So I was
Okay,
just
I wanna
curious.
answer it separately.
Mscher family, like I feel that they should do it right away from what you're saying, because if you don't have something in place, then the state takes over. So someone should consider that. But at what time, like what age for their child should they really make sure they do this?
Okay.
Yeah.
So just because I know it's 10:58.
Yeah, right.
So I'm going to answer it separately because estate planning and guardianship are so separate. Like they're just both important, but they're separate. So Kings County will allow you to file a guardianship proceeding at 17 and a half. If you know for sure that your child for sure will need a guardian, if you're in that boat where it's completely clear to you, you need to do it at 17 and a half. You could do it later, but it's not so fun to find out when you're at the hospital. It's much better to do it preemptively. Estate planning, making a will and stuff like that, that's the kind of thing that people need to do when they're ready. It's scary. Saying it's my husband and I, we always sit down and like start doing it. And like, it's very scary because I really hope that my life is going to change a lot over the next bunch of years. And an estate plan is supposed to change with you. And people do remarry and people have more kids and people have some new scenarios that come up in their life. And the estate plan is the kind of thing that changes a lot. And that really doesn't have anything to do with how old your child is or children are. That's really just like a plan you should be doing when you're ready to have that mature conversation about death, which is pretty scary. But guardianship should really be something you try to do as close to 17 and a half as possible. You could do it later, but it might be easier to do it before.
All right, everyone. We are at time for the next committee meetings, for the legislative committee meeting. Thank you so much. Thank you, Malkie, again for an excellent presentation. You will definitely come back to this committee and to present in other DD Council committee. And I will reach out to you later on if anyone reach out with questions and comments so we can do another Q&A sessions. Thanks, everyone. Thank
Have
you.
a great day.
A wonderful day. And we are
Have a
going to
Thanks,
start very
everybody.
soon.
Stay on for the next committee meeting, legislative committee. Thank you.
And just to remind everyone, the next meeting is on the calendar. Please note that it will be moved to the third Wednesday due to the Jewish holiday. Please make sure you look at the date right now. Same meeting ID number. As Rose said, if you have any ideas for speakers future, please email Rose, Sal, and Deborah Greif. Thank you, everyone. Rose, Debbie.
Yes, thanks.
Yes.
We did made our final announcement. Is the next committee meeting is going to be happening. It's 11:01, so I'm going to pass it up to Lucina.
That's right.
Mhm.
Everything will be on the website for the advisory and the Brooklyn DD Council. So thank you again. Rose, you and I will chat later.
That's right.
Thank you, everyone. Good morning,
Thank you,
good
everyone.
morning, good morning. And thank you.